Hello everyone and welcome to Indian Polity Classes. Today we are going to be discussing the topic who controls India's temples, and this topic has come recently into news when Supreme Court has reignited this debate by taking upon itself a case regarding four different states: Andhra Pradesh, Telangana, Tamil Nadu and Pondicherry and their religious institutions. What stirs this debate? And in India, who actually does control the temples? Is it the religious denominations? Is it individuals? Or is it the state? Historically, Indian temples have been very different than other religious denominations. Temples were not just spaces of religious conduct. They were also institutions which got land donated. We see in history, ever since Chola inscriptions, we'll find that lands used to be donated to temples for religious purposes and for the stay of the priests, etc. And also for the personal use of the priests. So we historically have come to distinguish at least between two different kinds of functions of temples. One is the strictly religious functions that the temples perform, and another is the secular functions that may also be associated with temples. And one such aspect is the control over property. Temples own huge tracts of land, not just the place on which they are established, but also other tracts of land which may have either been acquired by the temples or may have been donated by the temples. So where exactly can the state intervene? Can the state actually regulate your control over property? Is it just religious practices that are protected against state power? We'll go through this entire discussion in this today's lecture. We first begin with how the first efforts were made in India to regulate the affairs of the state. We will find that in early 1800s, from 1810 to 1817, for the first time when the Britishers tried to make an attempt to actually control the religious affairs of Hindu religion. They wanted to have an oversight on the religious temples, their leaders, their priests, so that these do not become centers of opposition against the British rule. Britishers anyway had a hatred towards the Indian religions, and they wanted that their oversight would actually help keep Indian religions in check. However, this saw a lot of opposition from the Indians, and Britishers did not want to pick a fight with the people directly. So by 1863, they had already passed a Religious Endowments Act, under which they declared that now the religious administration of temples will be passed on back to the priests and their religious administrations. So Britishers first stepped in, then stepped back. Then, as British provinces started gaining prominence, they started framing their own laws. And one of the first ones to do that was the Madras Presidency in the 1920s. Madras Presidency in the 1920s passed this Hindu Religious Endowments Act, and mind you, from a historical perspective, it was Justice Party in power in Madras Presidency. And Madras Presidency passes this act under which all Hindu religious endowments will now be governed. So this was the state making an attempt to enter into the secular affairs of the state. However, at this time, the secular and the religious affairs had not strictly been differentiated. They were all sought to be covered within the powers of the state. Then comes the post-independence scenario. When India got independence, we realized that we needed to have some sort of independence in our religious affairs. So we had added religious freedom within our fundamental rights. We had fundamental right under Article 25, your freedom of conscience, profess, propagate and practice religion. And you had fundamental right under Article 26 to establish religious denominations of your own choice. So both these fundamental rights put together come in the form of a nexus, Article 25 and Article 26, which protect your right to freedom of religion and also your right to establish religious institutions of your choice. And this was the post-independence scenario. However, within the constitution, there was a space provided for the state to be able to intervene in the affairs of the religion. Within Article 25, it was mentioned that while the state could not regulate your religious practices, it could regulate by law certain other aspects which was secular aspects, economic aspect, political aspects, civil aspects of religious endowments of these Hindu temples. And both the center as well as the state could make a law on it. That means this idea of religious endowments had been placed in the 7th schedule under the concurrent list, entry 28. But given the diversity that India has, not every state was governing their religious institutions in the same way. So when we became independent, that history continued and different states started creating their own different kind of laws to govern their religious institutions. So today, the question is not just who controls India's temples. The question is also how are Indian temples controlled? And the answer to that is there is no one single framework that controls the temples across India. They differ from state to state. And some of these examples are right here in front of you. In Tamil Nadu, if you will see, you will find there is the Hindu Religious and Charitable Endowments Act, and those departments are responsible for the governance of religious institutions in Tamil Nadu. In Andhra Pradesh and Telangana, you will find that state endowments have been created to control religious denominations. Similarly, in Kerala, you find Devaswam boards, and there are also temple-specific statutory authorities that have been created in India. And one such example is the Sri Jagannath Puri temple in Puri, Odisha. There is a specific body created by the state through a statute. And there are also examples where independent trusts continue to govern India's temples. And one such big example that has been in the news in the recent past is the Ram Janambhoomi. Ram Janambhoomi is governed by an independent trust. So there can be multiple models. There can be the Tamil Nadu model of charitable endowments, Kerala model of Devaswam boards, Odisha model of statutory control, or even independent trust control. So there is no one common framework that is there across India. Secondly, what comes under state affairs and what comes under religious affairs is written right there in the Article 25 and Article 26. Article 25 allows you to practice and profess your religion. It allows you the freedom of conscience. And Article 26 gives you the right to establish endowments of your choice. But within both articles, there are provisions under which state can by law regulate your religious institutions. And on the basis of that, these acts have been created. But what exactly is religious and what is secular, that had not historically been defined. The Supreme Court took this issue upon itself in 1954 when the Shrir Mutt case came into place. In the Shrir Mutt case, the Supreme Court laid down the essential practices test. It said only those practices of a religious institution will be protected which are essential to that religion. However, other practices may still be bound to control of the state. But this does not mean that state could have unlimited control in secular affairs. And since then, the court has retained the right to interfere in secular practices of every religious institution. In the Shrir Mutt case, we saw that religious practices and secular practices were differentiated. States were not allowed to enter the religious aspects, but could enter the secular aspects. Some examples of such things could be, if it's religion, you can talk about doctrines, rituals, practices. If it is the state, what exactly can the state regulate? State can regulate things like accounts, audit, these administrative officers of the endowments of the religious institutions. And that itself must tell you that ever since our jurisprudence has evolved. In 2012, a case came before the Supreme Court, which was regarding this very issue, that in the states of Andhra Pradesh, Telangana, Tamil Nadu and Kerala, these states have started interfering in the affairs of the religious denominations. And it was sought to be clarified what exactly can the state interfere in. In 2025, the Supreme Court had directed these petitioners to go back to their respective high courts and deal with the petition there. But in 2026, as fate would have it, the bench led by Justice B.V. Nagaratna has called back upon itself the case and is now going to decide what exactly is the kind of secular power that the state can practice and what is the religious practices that the state cannot. So right from the British times till the present times, there have been examples where we saw that the religious practices were sought to be controlled. Eventually the Britishers voted out of it, and then came the Indian presidency laws, especially beginning with the Madras presidency. Then came our constitutional framework under Article 25 and Article 26, and we decided that we are going to distinguish between secular and religious affairs within the religious denominations under the Shirur Math case. And I also discussed with you some examples of such things. So the Supreme Court today has revived this 2012 case, and only the decision of the Supreme Court will finally help us figure out who actually controls the Indian temples, or rather, how are Indian temples controlled? What is within the rights of the state and what is within the rights of the religious denominations? Let's wait and watch where the Supreme Court takes us, and until then, let's keep waiting for the next video. Thank you very much.